All right, good afternoon. Thanks for joining us. My name is Eric Huggin, the Executive Director at Homeline, and you are joining us on Wednesday, June 16th at 1:30 in the afternoon for one of our COVID-19 tenant landlord law webinars. And today, we thought we might have more news to discuss. We do definitely have some news to discuss, but maybe not in as much detail as we'd hoped and others would hope, but we're going to go through what we can and have another webinar in a week where maybe there'll be more details. Just a reminder what Homeline is. We're a statewide nonprofit organization, and our main program is a free and confidential legal hotline that renters can call and get advice about their housing situation in English, Spanish, Somali, and Hmong languages. There's our contact info. If you're a renter and you have a specific question about your situation, please give us a call. We have been doing these webinars since last April, and we've scheduled a couple over the next 2 weeks with varying degrees of news potentially happening in the next week or two. So again, we had thought there might be news this week with the state legislature going into session, special session on Monday. There's been some reports of an agreement on a legislative off-ramp of the eviction suspension, but no confirmed details yet. So we'll talk about that a little bit today, but maybe we'll be able to save more of next week for the details if they come out by next Wednesday. And then the 30th of the month is the end of the suspension and or of the CDC suspension, at least the scheduled end of the CDC suspension. So there may be news on that on the 30th and potential news on what's happening here in Minnesota with a potential off-ramp. And if there's news from the courts on how things are going, we'll try to provide updates. In just a moment, once Mike Bra, our managing attorney and hotline director, gets speaking, I'm going to throw in the chat a couple links so you can register for those upcoming seminars. But again, we want to remind folks kind of front and center that throughout the whole process, rent has been due over the last 14, 15 months. The suspension does not mean that rent is not due. And so there's two resources that we've been trying to highlight on these webinars and with our clients. And that's, of course, renthelpmn.org, that you can apply for rental assistance through the statewide emergency rental assistance program. If you don't have internet access, 211 is the place to call. There's been some reports about that program that's been somewhat slow, but I think yesterday or within the last day or two, it had been reported that they've had over 2,400 applications since opening in April. So there's a lot of folks that are applying and are waiting for money. And then just announced about a week or so ago, however, it closes, scheduled to close on June 20th, at least temporarily, is the Zero Balance Project. So again, the Rent Help MN, renters should go there to apply directly. This Zero Balance Project is for landlords, property owners to initiate an application, provide some of the materials up front. Again, it's only for rental housing in Dakota, Hennepin, and Ramsey counties, which does include Minneapolis and St. Paul. And I'll put more details in the chat on those programs. Besides that, we did get a number of questions in advance today. Mike's going to go through some updates on what's going on a state and federal level with the eviction suspensions. We'll get to some of those questions. We're happy to touch on questions that come in throughout the day. So please send them in via the Zoom Q&A chat portal thing. And with that, I'll hand it over to Mike Bra.
And just to be clear, you want the questions to be sent through Q&A chat we generally use for posting links to things that we're speaking about at the time. Okay, thanks, Eric. We're going to talk today about a couple of different things: the state eviction moratorium, the federal eviction moratorium, and where both of those are at procedurally, court cases. Let's start with the state version. It's the most certain front page news in Minnesota. I think it was on the front page yesterday of the Strib. And it's been widely reported in the media that there is a deal more or less being, well, considered, not finalized yet. We're still waiting for that. And until that happens, we're going to update you on the status of the eviction moratorium as of right this moment, which is not much different than it has been for 15 months. Monday was the latest 30-day extension of the peacetime emergency that the governor issued. We've had, I think, 15 times already the governor renewing that, and so it's 16 months of a peacetime emergency. The peacetime emergency is not just about evictions. It allows the governor to close restaurants, open restaurants, close salons, let you go see Twins games. Is the state fair going to be open or not? That kind of thing. But it also makes the state eligible for all sorts of things that otherwise they wouldn't be eligible for. As I understood it from the media reports this week, over 40, maybe 43 or 44 other states still have peacetime emergencies in place. So Minnesota is not exceptional at all in that regard, having a peacetime emergency. The eviction moratorium, what we've been speaking about since April of last year, is a different issue, but it is tied in time to the peacetime emergency extensions. The eviction moratorium, which started in March of last year, specifically refers to the peacetime emergency as sort of being, what it's relying on for the calendar effectiveness of the moratorium. As long as the peacetime emergency is there, the eviction moratorium remains in place as well, unless there was some new order from the governor ending the eviction moratorium. Or we've got a few other ways that the eviction moratorium could end. Either the peacetime emergency itself or the eviction moratorium could end legislatively, or there could be a court challenge as well that could end the eviction moratorium or the peacetime emergency. If you wanted to end the peacetime emergency, or I suppose the eviction moratorium, the legislature does have the power to do that on their own without the governor saying it's okay. All that would have to happen is both chambers of the Minnesota legislature would have to vote a simple majority to end the peacetime emergency or the eviction moratorium. They have not done so as of now. Every vote that's ever been taken in that vein, the Senate majority is Republicans, has voted to end the peacetime emergency. The House, where the majority is Democrat DFL, has voted not to end the peacetime emergency. Governor Walz, of course, is a Democrat. And so the peacetime emergency remains intact. The eviction moratorium remains intact for now. As Eric mentioned at the beginning, there is serious talk of a deal being close to finalized. In fact, let's roll on to the next slide and talk about what's been reported, if we could. Yeah. So as Eric mentioned, the legislature is in a special session right now. Why is that? The official legislative session ended over a month ago, I want to say. The peacetime emergency, whenever the governor renews the peacetime emergency for yet another 30 days, again, as he's done 15 times, the renewals, the special session is automatically by law triggered. Again, we've seen in past years, special sessions aren't exactly exceptional in Minnesota. They're not that special. Special might be the wrong phrase for it, because they aren't that special anymore. They're very commonplace. They seem to happen once every other year, if I'm looking back over the last 20 years. Maybe I'm wrong about that number, but they seem frequent. And normally where we see special sessions, if it's not a pandemic, is there's some sort of budget impasse that the two legislative branches can't get by. And so they end their legislative session without a deal, and then they negotiate. And then once a deal has largely been agreed to, then the governor calls a special session on his own, which the governor has the power to do at any point if there's no legislative session happening. And then the legislature can decide to do whatever they want once the special session starts, but they can't call their own special session. Here we have an automatic trigger of the special session. The governor doesn't need to say, I want a special session again. It's just going to happen because the peacetime emergency was extended. And so we are currently in a special session. It started on Monday. And the Senate and House did not both vote to end the peacetime emergency. So we're still in the peacetime emergency. But the legislature is still in session, trying to work through a lot of things. It's not just the eviction moratorium, but a lot of things. But the eviction moratorium, it was reported heavily in a lot of media outlets earlier this week that there is a tentative deal on the table between the House and the Senate describing what the eviction moratorium off-ramp, as people are referring to it as. I actually think it should be called an on-ramp to restart the eviction process is how I would view it. But that's the phrasing that's been used, the off-ramp for the eviction moratorium. The deal that's been discussed, and Eric just posted a link to a pretty good summary of it from MimPost, is that material breach would be added to the exceptions for reasons for evictions. As you may recall, there are exceptions right now to the eviction moratorium in Minnesota. A landlord can't file for non-payment of rent, or for somebody having a pet when they're not supposed to, or having a family member move in with them. They can't file an eviction for that. The landlord can't file an eviction, but there are some exceptions built in to the current executive order. The exceptions are, once again, seriously endangering others on the premises, causing significant property damage. If the tenant has violated a statute that forbids having drugs, illegal weapons, prostitution, stolen property in the on site, or if the landlord or their family member needs to move into that specific rental unit. Those are the exceptions that we have in place right now. The deal that's been reported on would add material breach to that list of exceptions. And that would mean that a landlord could file an eviction for somebody having a family member or a boyfriend or girlfriend move in, or having an unauthorized pet, or smoking in a non-smoking building. These have been the sorts of things that have been, when there have been articles in the media about landlords that are upset about the eviction moratorium, they'll talk about these types of issues, that we can't get rid of the disruptive bad apple tenants. And so the material breach exception would be added to the list of reasons why a landlord could file an eviction. Next up would be what's being described as a notice requirement, that the landlord would have to give some sort of requirement of notice in order to file an eviction. We have it's a little bit confusing about when landlords could start to file for non-payment of rent for tenants if they don't qualify for the financial assistance, probably in August, based on what the reporting looks like. And perhaps most importantly, as far as the points that are being reported, is that renters that have applied for assistance through Rent Help would be given some protection from eviction through June of next year. Anticipating that the Rent Help site is not quick, and we want to make sure that landlords get paid, frankly, and tenants get to stay in their home. It's a benefit to both sides if that's what eventually happens, right? If eventually the landlord gets caught up with payment, the tenant is no longer in debt. Both sides are better off than having an eviction filed. And so those are the components that are being reported on widely. Again, this is not a deal that's been signed by the governor yet. It hasn't been approved by the legislature. And in our experience, you have to wait until that happens before you can really summarize truly what a new statute or even proposed statute officially means. And if I understand right, Eric, I don't think that there's even been any official language of the negotiation published anywhere. Is that your sense of it still? I haven't checked this morning. I was giving another speech, so I don't know what the latest is.
Yeah, I don't think I've seen any reporting on actual final language. So there's a variety of different articles. I did post a min post one. There's
Mhm.
one actually in the Minnesota Reformer that actually talks about some timelines, like the
Mhm.
dates. It's 105 days total. I can post that Minnesota Reformer article. But again, I think part of the deal here is that there's not maybe a finalized decision. I think one of the things that we've sort of known all along is that you know they're leading up to they're already in a special session, and they're leading up to the deadline that the legislature has for a budget, and so this is one of multiple other priorities that they're juggling at the Capitol, and so it sounds like maybe what happens is uh, they're getting close to a deal on something, but it might be dependent on other things, other aspects of housing bill, or maybe something even entirely else. So it's hard to know that, but the variety of reporting that's been out there since I think Monday or midday Tuesday has sort of highlighted these few things. The MinPost article also, I think, talked about that there was some stuff that one side was trying to get that the other side maybe didn't get. One of which is including the MinPost article says not included in the deal is a Senate or GOP priority of permanently changing the governor's power to issue orders that ban evictions. And then, but then also a priority for the DFL House was around getting tenants' eviction records removed easier. So not a ton of details that can be shared right now, and or that's out there in the public to actually be able to say this is what's going to happen. But the thought is, I think they've been reporting that the hope was that they were only going to be in session for like 7 to 10 days, or maybe until the end of the month. So maybe it will happen, and that's why we are going to host 2 more webinars really focused on this issue the next 2 Wednesdays. Hopefully we'll have details that we can share and talk through and answer questions. Yeah.
Okay. All right. Well, let's go on to the next slide, and we'll talk about a new issue, a brand new issue, which is there was another court case filed challenging an eviction moratorium. This one is the state moratorium that's being challenged. We have talked at length over the last couple of months about challenges to the CDC federal moratorium, and we'll talk about that in a second as well. But we have our second significant court challenge to the state moratorium. There was a similar case filed late last year. Landlords lost, asking a federal district court to rule the state eviction moratorium unconstitutional for a variety of reasons. There's a lot of similarities between that case and the case that's been filed this week. There are some differences. First and foremost, for what we have written on the screen here, this time it's not just a group of landlords that have filed the case in district court, but also they are joined by the Minnesota Multi-Housing Association as one of the plaintiffs, which I don't recall seeing their name on many lawsuits in the past. They are a very known entity in Minnesota, the landlords trade group. They do a lot of lobbying for landlords, some trainings as well. Anyhow, their name is attached to the lawsuit as well. And there's quite a bit of the case that I read where it's talking about who they are, what they are, why they should be involved in the suit to justify their what's referred to as standing in legal terms. Again, reading over the case, I've read it a couple of times now. What they're arguing, the key components to what they're talking about, and the things that sort of caught my eye in reading the filing that they submitted this week on Monday, is first, the state moratorium has eviction exceptions that have proven almost impossible to meet. I can't agree with that hyperbole. I think it's just too much. We did 2 webinars, one about halfway through one calendar year, and then another one at the end of the full calendar year, where we talked about the evictions that were filed. during the pandemic. And in the last 5.5 months or so of that 1 year period, so it would have been October through March, I believe there were between 600 and 700 evictions filed in Minnesota. So that means that landlords don't seem to think it's impossible to meet. They're not easy to meet necessarily. Again, we have the exceptions that we talked about, the endangering others, significant property damage, et cetera. But there have been plenty of cases filed in Minnesota for evictions, and many of them have been successful. So they can be done. They're not as easy as they used to be, for sure. But calling the eviction exceptions impossible to meet, I think is just a little too strong of language. But that's what lawyers do. They try to make an argument. The case, or the request for the judge also asked or mentioned the fact that it's been declared safe to go out to restaurants, to go to gyms, go to a concert, that the state fair is going to be opened, and evictions and non-renewals should be included in that list. They went on to talk about how the executive order 2079, the one that is the eviction moratorium, the current one that we're using, that's been in place since September of last year, isn't necessary or tailored to protect the public from the spread of COVID-19. And that a last interesting argument is that the CDC order effectively covers tenants that are trying to come up with a rent payment. So it compares and contrasts the state moratorium, which does not require any sort of declaration from a tenant to say, I don't have the money, or I lost my job because of COVID-19, or I got sick because of COVID-19, or I've been trying to qualify for financial assistance. Tenant's not required to do any of that in Minnesota under the current eviction moratorium, whereas under the CDC moratorium, there is a declaration a tenant has to give covering some of those issues, plus there's an income limit on the CDC protection. So it points to the CDC as an example of how it could be done. Interestingly, there's other landlords throughout the state, the country, that have pointed at the CDC saying that's a terrible way to do it. They shouldn't be doing this at all. And then the case goes on to make the typical arguments that we've seen landlords make throughout the country when challenging any of these eviction moratorium, that this is an unfair taking, no due process, that kind of concept, that it's a violation of contracts. Those sorts of things are the type of arguments that show up here and have shown up in many other cases around the country. It's odd that this case became publicly filed on a day when there started to be reports that there was an off-ramp agreed to. This case actually mentions the off-ramp. The filing mentions the off-ramp and how there's an off-ramp that's been debated and promised for months and months. But it isn't there yet. And so there's sort of an implication that if there was an off-ramp, the case would just disappear or be dismissed, is the more technical term. There's no guarantee of that, of course. They might stay with the case, but that's a case that's been filed. So a bit more pressure on the state moratorium. I'm not sure, having looked at 10, 12 of these cases from around the country, how much chance I think this argument has. When a very similar case was filed in this exact state, a little less than, or was decided at least less than 6 months ago, I'm not sure of their chance of success if the eviction moratorium didn't go away. Let's say the numbers on vaccinations just peaked, and suddenly we had hospitalizations and fatalities shoot up again. And the governor pulled back on everything and says, no, we got to keep the peacetime emergency. We got to keep the eviction moratorium. I'm not sure that this case would succeed. It's hard to know. It's always hard to know. You can't really predict what a judge might do. But anyhow, the case has been filed. It's active. And so it's something that we should all be aware of. It certainly relates to this. And it's a little more pressure for the Minnesota eviction moratorium to bear. Okay, I've mentioned the CDC moratorium several times. Let's go on to that next slide, Eric. Thanks. Here's a summary of where we are with that. So I keep throwing that phrase around, the CDC moratorium. That's the federal eviction moratorium. It's routed through the Center for Disease Control. It has been since September of last year during President Trump's tenure, when an eviction moratorium was decreed throughout the land for non-payment of rent cases. Now it's just for non-payment of rent cases, so it is limited, unlike the state moratorium, which is much more expansive, right? You can't evict somebody because they have their their family member move in, an adult family member move in normal times, you probably could evict them for that as a landlord. During the pandemic, you can't. The CDC is just about preventing non-payment evictions. It does require, as mentioned, it's not an affidavit, it doesn't have to be notarized, but a declaration under penalty of perjury that the tenant provides to the landlord saying, my income is under $100,000 a year if I'm single, under $200,000 if there's two or more of us. And I've done everything I can to come up with the money and I don't have it. And I'm working on it, that kind of thing. That isn't required with the state moratorium, but it is required at the CDC federal level. The CDC is in its moratorium is in its fourth incarnation at this point, or its fourth version, fourth time period. The first one went from September of last year through the end of the calendar year, December 31. The next one was only a month. We had a new president elected, and Congress and President Trump seemed to say, let's just delay this decision for a month. So that was a rubber stamp from Congress at that point. That ended on January 31. It was renewed through March 31 and subsequently renewed through June 30th. Now, today is June 16th, right? We're closing in on the end of the CDC's current moratorium on evictions. Will that be extended is a very legitimate question that I don't think we really have a solid sense of right now. I think that I'm not sure if you can bet on this in Las Vegas. I'm sure you can bet on it somewhere. But the facts that one should consider, if you are considering placing a bet on this, would be that the extensions have been announced traditionally very late. So the one that happened in December was December 28th, I want to say. The one that happened in January, extending it through the end of March, was again late in January after President Biden had been sworn in. The one that ended on March 31, again, announced very late in the month, maybe the 29th or the 28th, I can't remember exactly. So the fact that we haven't heard anything, that there hasn't been an announcement of an extension yet, isn't necessarily a fatal analysis of will the CDC moratorium continue or not. COVID has receded to some degree, right? I mean, we're opening up throughout the whole country. And so maybe the appetite for an eviction moratorium extension has lessened to the point where it will not be extended. But it has been challenged at the court level several times in throughout the country in several different what are called judicial districts. The most important case that has analyzed this is all the way up to the Court of Appeals in the DC circuit. Sort of there's about a dozen federal circuits, and it's seen as the most important of the circuits when it comes to rulings on things like this. And so it seems likely that unless we get the Supreme Court to hear that case, which was filed by a group called the Alabama Association of Realtors, then it's probably going to stay in effect. The CDC moratorium is the best analysis one can probably glean from what we know today. The Alabama Realtors have filed for an appeal to the Supreme Court to ask them to overturn the Court of Appeals decision, to overturn the district court's decision to enjoin the CDC from doing this. But as it stands right now, the CDC moratorium is firmly in place. Probably throughout the country, although there's a couple districts where you could make the argument that it's not true. But anyhow, will it be renewed? We don't know. Will it withstand court challenges? Well, the Supreme Court might decide to hear it. It's one of those things that you'll hear people say all the time when talking about any kind of litigation. I'll take this to the Supreme Court. I'll take this to the US Supreme Court. Well, the truth is that door's not open for most people. There's about 7,000 cases filed in the US Supreme Court on average each year. They hear about 70 to 150 if it's a busy year. So they turn down most cases. They just say, we don't really need to hear that. We think the Court of Appeals got it right, or we don't think it's worth our time to address that issue. It's not of enough importance. And it's their discretion completely to decide whether to take a case or not. So will they take the case? We don't know. Will the CDC moratorium be extended past June 30th? We really don't know. We know that we're going to do one of these presentations on the 30th, and we decided to do one on the 23rd because of the fact that as of today, there is no state off-ramp that we can talk about authoritatively. It just doesn't exist yet in a final form. So that's why we're going to be doing these the next 2 weeks. Let's say for a second, just kind of talking through this, that there is a state off-ramp agreed upon. The House, the Senate, the governor, they all sign off on a state eviction off-ramp. If the CDC eviction moratorium remains in place, it still would have a role, or it would have a role, a new role in Minnesota. Right now, it's more of a backstop than anything else. Doesn't really play much of a role. But if the state moratorium went away, the CDC moratorium is potentially still there for who knows how long it'll be renewed for. At one point, it was rumored that it was going to go through September. But that was back when the March renewal was being considered. And so we'll see. We'll see whether it gets extended through September or not. But if it does, a decent chunk of the negotiation of the off-ramp will have, the Minnesota off-ramp will have less of an impact on the actual state of affairs between landlords and tenants in Minnesota, especially when it comes to non-payment cases. Okay, I think that's it for the CDC. I know we have half a dozen or a dozen questions that were submitted in advance, and a couple that have already come in. So why don't we go ahead and go on to what's next here, Eric?
Let's do that. Yeah, we have maybe 8 or 10 questions that we got in advance. So we'll get to those first. But if you have a question about any of the content we've covered today, please send it over the question and answer tool. Okay, so sometimes some of these are a little bit repetitive of stuff you've covered, but we'll go through each of them. The first is from Jennifer, who I believe is a service provider. The tenant owes back rent, lease expired, so decided to move out. Now not eligible for rent help MN. Now what?
So kind of built into that question is that statement, now not eligible for rent help MN, which is probably accurate. As we understand it, rent help will not pay a back debt that a tenant has if they're not still in the place. It has to be their current rental that the rent help is trying to settle up on. And I know that we've heard people wish that that wasn't the case, but I think that that's still what we believe the story to be, is that rent help will not satisfy an old debt for a place that the tenant no longer lives at. So if this is a service provider, I assume she's, working on behalf of the tenant. Jennifer is. So the tenant owes some money back. They moved out. Now what can the tenant do? Well, so the landlord says that the tenant owes a debt at this point, probably. I'm not sure if the landlord is chasing the tenant for the money, or through court, or through a collection agency or something like that, or if it's simply affecting the tenant's credit. But it's one of those situations where if tenant has an old debt, they can do a couple of different things. They can ignore it and hope it doesn't impact them, which sometimes is the case, sometimes it's not. I think it's very difficult to assess right now what impact a debt incurred during COVID will have on somebody's future. There may be, I've talked about this a couple of times in one of our other 52 sessions that we've done before, but I've been doing this long enough to have been an attorney working on behalf of renters through the foreclosure crisis, 2008 to through 2012. And many of our clients were former homeowners at that point that were looking for housing, and they'd been foreclosed upon. And that was really the one giant blemish on their application, their rental application. They had good criminal history or no criminal history. They had no bad rental history, but their credit was shot because of the foreclosure. And there was a strange phenomenon then where landlords started caring less about credit because of the fact that they needed to rent the place to somebody, and these people needed a place. And chances are those folks that used to be homeowners probably were the type of people that wanted long-term rentals, because at one point they bought a home, they probably figured they wanted to be in that place for a while. So I'm sure they were seen in some regards as more attractive applicants than others that would want a longer term lease. And we started to see the dawn of 2, 3, 5-year leases at that time. prior to that, in my career, I've been doing this since 1996, seeing a 2-year lease was exceptionally rare. They really started to happen a lot in 2009, 2010, 2-year leases, 3-year leases, 5-year leases. And you know what they're about. It's the tenant is thinking that's when my kid's going to be done with school. And that's what they're planning their entire lease on. And I want to make sure I have a stable place once we got foreclosed on. And landlords started de-emphasizing the foreclosure past that tenants had. Will that happen again? Will landlords give people something of a pass because they ran into trouble during COVID? I think that's impossible to know. I think it's possible that it happens, though, to some degree. And I also think that there's likely to be a lot of bankruptcies filed by not just tenants, but people that have debts that were incurred during COVID-19. As debts become due, as government subsidies and stimulus packages end, I think that more of those types of things might occur. But I mean, the tenant could talk to the landlord if they are being chased for the money about, hey, I'll give you half the money, or make them an offer of some percentage of it to see if the landlord will take it in exchange for wiping out the debt. Or the landlord can, like I said, take them to court and try to collect the money, but it might be hard to find the tenant or collect the money eventually, even if they do know where they're at. Long answer, sorry, I went in a tangent there.
Fair enough. The next question is somewhat related, maybe a little bit. Greg, who is a landlord, it looks like, says that shortly after the announcement of the stepped down off ramp on Monday, so just this past Monday.
And let's just stop for a second there. That's not official yet.
Yep.
There was an announcement. I don't blame Greg for saying, hey, there was an announcement, right? Because it did seem like an announcement, but it isn't final yet. Anyhow, go ahead. After the step down off ramp announcement.
So there was this announcement on Monday. The renter asked to tear up their last rent check because they had applied for renthelpmn.org. They have been month to month for the past 16 months and current up until last month. If we forgive them all past due rent, including this month's rent, they are now current. Can we move toward eviction? Our plan is to sell that house, but need them out to remodel first.
So, okay, there's a lot there. The whole concept of the tenant asking the landlord to tear up the rent check that was just submitted, I'm sure isn't what Rent Help was thinking they were designed for, but it might be eligible. Let's just assume that it is for a second, but that would only help if the tenant is planning to stay in the place. The Rent Help doesn't work for Greg if he's just going to make the tenant go. And so I'm not sure that this agreement to get the government to pay this last month's rent, I don't want to, the word that comes to mind, but it's too dark a word, is collusion here. And I'm not sure that Greg hasn't cashed the check. It'd be a little surprising if they haven't. I mean, it's the 16th and it depends on when the check came, but regardless, can the landlord make the tenant move out to sell the house is a fairly common question that we get. Landlords are wanting to sell their property for all kinds of reasons, just like they do every year. Maybe there's more this year, maybe there's less, I'm not sure. But under the current moratorium, the one that we have in place today, a landlord couldn't non-renew or give a termination notice simply because they want to sell the house. The closest exception would be that the landlord wants, or I'm sorry, not wants, needs, that's the word, needs to move into the rental on their own, or a family member of theirs. That's what it takes, is that the landlord needs to live there. Without that, I don't think that Greg's hope for here is going to work. Tenants have left. Landlords have sometimes say, I want you to go. I'll give you a 3 months rent if you leave, because I know that I can't make you leave today. That has happened throughout the pandemic, and tenants and landlords are free to negotiate over this. But can the landlord use the eviction is the real question, to force a tenant out if the tenant won't go at the end of the lease and the landlord's given a notice that normal times would have been sufficient. Yeah, so again, there's a lot there that Greg is dealing with, but the big picture answer is you can't make a tenant move out to sell the house, at least right now. Yeah.
Yeah, and just because you raised it in the last two questions, I believe that the rule for both Rent Help MN and this new Zero Balance project, because I think they're both coming from similar funding sources, is actually a federal treasury rule that the money has to go to a tenant to maintain, or to the landlord on behalf of a tenant to maintain housing stability. So that's a rule that the feds, I think, put in place.
And it's not especially surprising. That's how most subsidies in past years have been designed, that it was to stabilize a tenant's current precarious situation, not to pay an old debt. So not especially shocking to see that that's the way it's being dictated here.
All right, Joel, who I believe is a landlord.
I think that's Joel.
Maybe
Yeah.
it's Joel, sorry,
Yeah.
apologies. When will we be able to evict people with balances that refuse to cooperate with any of the programs and also refuse to pay?
Yeah, this is a great question, and I think it's a very common question that I've heard from landlords since we started doing this sort of thing. I know some landlords that have asked me about that concept as well and what can be done. And for a second, I am just talking to landlords out there. We have a wide audience of people that watch this: landlords, service providers, tenants, policymakers. But if I'm a landlord, let's say you've got a tenant that owes you $6,000 to $10,000, a lot of money. You need that money to make your landlord business go. Now, you might not think of yourself as a landlord in business. There's a lot of landlords that own half of a duplex. You don't think of your landlording as a business necessarily, but it is. It's just sort of a smaller business. You probably have another career that's taking up the majority of your time. But let's say somebody owes you a lot of money and you want to get them to cooperate with you to pay this rent back. The reason why you want to do that is because, well, you've got another option. Eventually, you'll be able to file an eviction for non-payment. We don't know when that's going to happen. Is it going to be July 1? Is it going to be October 1? Is it going to be some day in between, some day beyond that? We don't know exactly until the decisions get made. But some point, it's going to open up again. At some point, landlords will be able to file evictions for non-payment of rent. And on that day, when you're able to file for non-payment eviction, is that your best move as a landlord? And if your goal is to regain possession of the property, then absolutely an eviction is the right move. If your goal is to get money to cover the money that you've lost or that you weren't paid during the pandemic, an eviction probably isn't your best move. It probably is not. If you win the eviction, which is a summary proceeding, it can happen as quickly as 2 to 3 weeks. We're not sure how long it's going to take once the courts really open up again and the actual mass number of evictions get filed. But let's say it happens quickly. Okay, you recover possession of the place. At that point, you're probably never going to get the money. Now you might, right? You could go get a judgment against the tenant. You have to go to a different court to get a judgment. And if they're working, you can maybe garnish their wages down to the minimum wage level. If they've got a bunch of money in a savings account, you can swoop in and take that. But if they don't have a lot of money, and maybe you can't even find them, maybe they've moved to another state or they've died. I mean, it happens. Are you ever going to see that money once they move out? Your best shot to get this money as a landlord is to try to convince the tenant to apply for this assistance. Now, Joelle's question is saying, hey, they're not applying. How do I get them to apply? Well, okay, you'll have a new tool in the box when evictions become available to you. Hey, tenant, look, if you apply, I'll wait because I understand there's a lot of money. And we're not kidding when we say there's a lot of money. What is it, $600-700 million that Minnesota has, I think, in the bank at this point that they get to use to pay out for renters. And that's it. It's earmarked for just that. Minnesota has the money. It's not a theoretical hoped for dollar number. This is real money. So I want to get access to that money, tenant, but I can't do it unless you apply with me. We both have to do something, at least some signature somewhere, before we're going to be eligible for this money. And I know you haven't paid and you probably got behind and you thought you couldn't catch up, but you can. I guarantee you that there are tenants out there that don't know that they can apply for this money, or they think they're not eligible, but maybe they make too much money, or at least they thought they make too much money, and they might be wrong. They've never applied for public assistance in their life. There's going to be a lot of those people. And it's a little bit confusing and mystifying to think that Uncle Sam is going to pay this through Minnesota. why is Uncle Sam going to pay my rent? It's not very intuitive. And so there are tenants out there that just don't understand it. There are tenants, of course, that are gaming the system. But the system changes when the eviction doors open up again for landlords. When that happens, if I'm a landlord, I'm going to say, okay, you haven't paid. We can apply for this together. Or, I guess I have to start an eviction. What do you want me to do? Because I'd rather get paid. And I think you want me to get paid too, because then you get to stay here, at least for a while, and you'll get your debt paid off. So it's better for everybody. You wouldn't have to file for bankruptcy or worry about a judgment hanging around your neck later on when you're trying to move on in life, right? And slowing you down. So there are things in it for both sides. But when the eviction door is open, I think it changes the negotiation posture for both sides. Right now, it's pretty easy for a tenant to say, I don't care, landlord, leave me alone. I'll pay you when I get to it. That you can't file an eviction against me. But once the eviction door is open, the conversations shift, and the negotiating stability for a tenant refusing to pay is gone at that point.
All right. The next question from Allison. Does the no eviction till June 2022 apply to renters not qualified for rental assistance?
Yeah, again, we don't have, Allison, the final language of the bill, but from what I've understood in the media, that is for tenants, the June 2022 is for tenants that have applied for the rental assistance and are in the process, I think. Is that your understanding of it, Eric? I think there's a different rule that's being kicked around in the media for tenants that were ruled ineligible, right? Once you've been ruled out.
Yeah,
Is that what you've sensed?
So the Minnesota Reformer article, which I posted just a bit ago, does break this down. Again, this is a media report about a negotiation, so it's not what the law is, or at least we don't know if it's what the law is. But the agreement would prohibit eviction for non-payment of rent for tenants who have pending applications for rental assistance, and that will last until June 1, 2022. Landlords are only able to receive assistance for tenants who are living at their properties. Then there's a separate whole section that they reported on that has these different timelines: 15, 45, 75 days, and 105 days. Again, it's probably easier for you to click on the link and read the Minnesota Reformer article to understand what each one of those are, but some of them are regarding permission to non-renew or evict for somebody who's ineligible for assistance. Now, of course, I think something worth pointing out on this is what I think I said this earlier in the call, is that just, I think yesterday, KSTP reported that there's been 24,000 applications since April 20th to the Rent Help MN program. They've paid out 830, or over 830. That is 3.4% of the applications. So, and that was April 20th. So it's just another sort of realization that it takes time for those dollars to come through, and that's why there's that June date, I think, or at least what they're reporting is
the June 2022 date. Yes,
yeah.
Right.
So again, yeah, with the caveat that this is not the law yet, maybe we'll be able to report on what the law is, or the proposed law next week. Unfortunately, it's just not been public. Just reports of it have been. I lost my question list. There we go. Anna might be a service provider.
I think that Anna has submitted twice. I think she's the bottom one is the one that's more thorough, probably.
Okay, yeah, good point. What if, so the question is, what if the tenant left without paying? Landlords were not able to evict people because of the moratorium, and they left without paying. How will landlords get reimbursed? So that's similar to one of the earlier questions.
Yeah, and it's not any different than before the pandemic. Landlords are going to maybe file a case in conciliation court. Again, you can sue for up to $15,000 there, or they'll turn it over to a collection agency and try to essentially pressure the tenant into paying what they owe. As near as I know, there's no program out there that's going to simply pay that off for the tenant to cover their cost. So we have tried to emphasize that throughout, because again, we have an audience with not just tenants and social service providers, but landlords listen to this as well, that waiting to get the federal money from a cost benefit business analysis is probably the best move for most landlords to take. If the tenant just goes, there's not much a landlord can do to stop them from leaving. And it's too bad that they got left with a big bill. But they're left with the same options that a landlord would be left with before the pandemic. Again, small claims court or district court if it's above $50,000, or a collection agency if they can go that route.
All right. Question from Missy. When can lease terms begin?
Yeah, I'm not exactly sure how to answer that. I think that sort of built into that question is some concept that maybe you can't sign a long-term lease right now, which is a question that we've gotten sporadically on our tenant hotline since the pandemic began. There's nothing stopping a lease from starting right now, or from a long-term lease starting right now. So if somebody's thinking, whether it's a landlord or a tenant, hey, I want to do a 1-year lease or a 2-year lease or a 3-year lease, is that okay during this pandemic? Yeah, it's done all the time. I do believe that we are in an era where we have more month-to-month tenancies right now than we've ever had, certainly in modern times, mostly because of holdover tenancies, rollover tenancies, where a tenant was there for a year and then they stuck around after that because moving was more difficult because of the pandemic. Landlords couldn't non-renew somebody that they thought was problematic. So there's just been less turnover. And we're in our second turnover cycle at this point during the pandemic. So when tenants in Minnesota move in and move out tends to be a 6 or 7 month period from March or April through October. Landlords don't like tenants moving in and moving out in January. Tenants don't like to move in or move out in January. It's no fun for anybody. And so that's when those sorts of things are scheduled typically to happen, when leases are supposed to end, somewhere in that range. And right now we're in our second sort of turnover season. And landlords, knowing that they can't non-renew and tenants not exactly sure what's going on, might not want to sign on for another 1-year lease. So I think there's no way to really know this number, but I think we have a much higher percentage of tenants in month-to-month leases right now than have been the case in modern times. But that doesn't mean you can't have a longer-term lease.
Right. Keith, who's a landlord, asks, what if tenants owe rent prior to March of 2020? Can they be evicted?
Holy cow, that's yeah, I mean, sure, there are people out there like that, Keith. And the reason I had that reaction was it's a question that we don't really get much of anymore. There was a series of cases that were filed where landlords had the final piece of paper in an eviction that they're hoping to get, called a writ of recovery of the premises, issued in March of last year. And I'm looking at the governor's order again, because I haven't thought about this issue in months, because it's a little bit on the old side right now. So a writ issued as a result of an eviction judgment entered prior to the enactment. Yeah, so if a landlord has a writ, I guess they might be able to try to enforce it right now, although maybe it's expired now. I'm not exactly really sure. I don't think that's what is really being asked in the question, though, which is probably more along the lines of, can I go file an eviction today against a tenant that owes rent predating March 2020? And the short answer, I think, has to be no, you can't. It's a non-payment of rent eviction. It doesn't mean that the tenant doesn't owe the money. I'm not exactly sure what would happen with rent help or the federal programs, that whether they would pay back rent that was due for predating the pandemic declarations. But can you file an eviction for rent due prior to March 2020? Right now, no, you can't do that. Not under the state moratorium for sure, and probably not under this. Well, maybe you could under the CDC moratorium. I'm not sure about that answer, but under the state moratorium, no, it couldn't be done. Not today.
And so there's a question that I'm going to answer in the chat or in the Q&A about rental assistance programs, since this is related to it. a question about what was that other new program. So I'm going to put both of those in the chat again. And I guess I can put them up on the screen if I can figure that out. But Sandra was asking, could you please repeat the name of that new rent help program that recently went into effect? So that is the, oh boy, where are we? Yeah, the Zero Balance Project again. And I think the rules for both Rent Help MN and the Zero Balance Project, which the Zero Balance Project is one where the landlord begins and kind of leads the application process, versus Rent Help MN, which mainly the tenants apply. Landlords can put their information in there in advance, but so that's what's different about this program. It's only for Dakota, Hennep, and Ramsey. And I think the rules are the same on the both, that they can go back to sometime like mid-March 2020 to pay back rent. So that's how I think how far they can go back, up to 15 months total for both of them. Okay. I think
Looks like there was one from Ashley still in our
yeah.
list from before.
So is there a possibility of renters receiving financial help without an official notice to evict from the landlord?
Ashley is a service provider. Yeah, I don't think that you need a official notice to evict from the landlord to be able to apply for rent help. I think the tenant can start the process. It's a good question, Ashley, and I understand why you're asking it, because pre-pandemic, many of the potential sources of financial assistance that might be available to a tenant required either an eviction being filed, the actual court case being filed, or some sort of notice from the landlord saying, I'm going to go file an eviction against you if you don't pay up. But I don't believe there's a requirement of that in the rent help. I think the tenant can just start the process saying, I owe a bunch of money. At some point, the landlord's going to have to say, yes, they do owe that, to confirm the dollar number to some degree. So there isn't really a way for one side to apply completely alone. A tenant needs the landlord to ultimately sign off on it. A landlord needs the tenant to sign off on it if they're going through the zero balance approach. You have to have both parties involved in the ask at some point to fill out the final version. But there's no requirement for an eviction to be filed. There's no requirement for a notice of paying up, or else I'm going to kick you out. It's a good question though, Ashley, but I don't think it's required under these programs.
There is, I mean, one of the tenant documentation items for Rent Help MN says assistance request documents, past due rent statement, tenant ledger, invoice from landlord showing what you owe. But then there's this provision, I think, that allows tenants to certify, self-attest how much is owed if they are unable to get that from their landlord, I believe. Again, we're not the experts on
Yep.
Rent Help MN. We definitely refer to a lot of folks to them. And if you have questions about your rights there, call to, review their website and call 211. They can get you in touch with community partner groups that are helping walk folks through the process. Okay, I think we're going to questions that have been submitted right now, right?
Yeah, the ones that I didn't research for hours and hours beforehand. So yeah, who knows what the answer will be.
All right. What if anonymous question, what if a landlord and a tenant both lost lease or had a verbal lease and money owed for past rent?
Oh, okay. So I think what this question is asking is, how do they show what money is actually owed? I think, is that what you're sensing they're trying to figure out here? How are they going to convince somebody that that's what the dollar number was owed is? So yeah, in Minnesota, there's no requirement in general that somebody has a written lease. There are some situations where it is required. If it's a big building, for instance, 12 or more units, then it has to be in writing. But in general, there are handshake leases. Our best guess, running a tenant hotline and talking to a lot of people over the years, maybe 5-7% of leases in Minnesota are handshake deals. Maybe that's on a little high side, but I would be comfortable with 5% for sure if I'm making a conservative guess. So how do you prove how much money is owed for the past rent? Well, number one, I think you'd have to show what the actual rent was. What's the agreed upon rental amount? Very easy to show if there's any month ever where it was paid in a way that can be proven. If the tenant paid with a check, then they can go back and produce the check, or a cashier's check, or a bank money order, some sort of electronic payment. Any of those are going to be enough to show what both parties probably thought the rent was. And then from there, you can try to figure it out. This might be something where the landlord's going to have a bit more of a burden to produce a rent ledger, which is not something that's officially required in any sort of eviction for non-payment of rent, but it sure is a good idea for a landlord to have that in case the tenant says if they're ever challenged in an eviction hearing for non-payment of rent, and the landlord has said, hey, the tenant didn't pay the rent, and the tenant says, yeah, I did. I paid in cash like I always do. You didn't give me a receipt. You never give me a receipt. I asked for one. So that's the kind of thing that a landlord should want to have, is some form of accounting system where they can show the months the tenant did pay, the months the tenant didn't pay. Another piece of the puzzle that I would tell a tenant about, if a tenant were asking me about this, is, well, let's look at the CRP if there was one, the credit for rent paid, which every January a landlord is supposed to give a tenant a filled out form showing how much rent the tenant paid for the last calendar year. The tenant can use that for a property tax refund because they don't own property, but they're contributing to the property taxes being covered. And so that would be a declaration from the landlord. Hey, they paid me that amount last year. That was the full amount of rent they paid me last year. So if rent was paid every month for that last year, again, we could probably glean from that what the actual rental amount was, and also that it had been paid. So we'd know that the tenant was current through December of 2020, which doesn't answer all the questions, but it answers a decent chunk of them. Those are the kinds of breadcrumbs somebody would look for in trying to figure out how to convince a judge or rent help MN that this is the real number that's actually owed. And again, it's the kind of thing where if the landlord and the tenant both, sign on saying this is the amount owed, then that's maybe going to be sufficient. I don't think there's a requirement that somebody submit the written lease in rent help, because there are people in this state certainly that do have nothing but oral leases.
Yeah, and while you were speaking there, I just looked at the rent help MN application, and it does say, if you have a ledger available, attach it, check here, etc. But then the last 2 pages of the application actually are a fill in the blank rent ledger to say how much was due, how much I paid as a tenant, any fees, and the amount still due. So, and then the zero balance one, it does appear to say that a rent ledger is required by the landlord to prepare the application.
Well, a rent ledger can mean a lot of things, though. It can be just a notebook piece of paper with, a couple columns on it. But yeah, a smart landlord would have something in case they're ever trying to prove that somebody didn't pay.
All right. Another anonymous question or comment. It appears that 35 states no longer have any sort of eviction moratorium in place. Have any of those states noticed any problems with their evictions, such as renters going homeless?
Okay, well, so built into that question is a statement. It appears that 35 states no longer have any sort of eviction moratorium in place. That may be true. I haven't looked up the exact number of state eviction moratoriums, but the federal eviction moratorium is still in place. The CDC eviction moratorium for non-payment of rent, and I can't speak with authority on why evictions are filed in other states. I can only really address that in Minnesota. In Minnesota, over 90% of evictions are for non-payment of rent. If it's anything like that in other states, then the CDC moratorium still stops most evictions from occurring. So we have had during the pandemic a couple of windows in time where there were some states where evictions were allowed for non-payment of rent. So pretty much every eviction. Right, every eviction was allowed for a brief period of time. We had originally in March or April of last year, the CARES Act came into play, which did not allow evictions in CARES Act covered properties, which was limited to any place with any kind of federal subsidy, or if the owner had a mortgage that was federally backed by Fannie Mae or Freddie Mac, then the CARES Act stopped evictions for non-payment then. But then there were some times after the CARES Act sunsetted where a landlord could have given a 30-day notice. So there was about a week where landlords could file an eviction in lots of states around the country with pretty much no limitations. And what we saw in those states was media reports of landlords lined up down the street out of the courthouse, waiting, with a stack of papers, waiting to file all their evictions against the tenants they needed to file evictions against. Like it was, the hottest concert ticket, basically. And so will people become homeless if the eviction moratorium is lifted? Yep. I think that's a guarantee. It's a matter of the numbers. How many people are going to end up going homeless because the eviction moratorium gets lifted? How many people are going to get displaced? Homeless can mean a lot of different things. Are you doubling up with somebody else, which not only means you're precariously housed, but you're also making that person who you're staying with, their housing precarious, especially if they aren't authorized to have somebody living there. The actual definition of what homelessness means has shifted over time. It's actually a controversial thing that's fought over at the federal level fairly regularly. But yes, the eviction moratorium being lifted will absolutely have a huge impact. Right now, it's not truly felt throughout the United States because the CDC moratorium is in place. And so that's what we have in place right now. July 1, if the CDC extension is not decreed by the CDC, then will we see another rash of evictions? I have to think we will, yes. I can't imagine that we wouldn't based on what we've seen in those brief windows in time. Although the federal money that we're talking about, the Rent Help Minnesota, is money that's not just for Minnesota. Well, the money in Minnesota is, but every state has an allocation of money. And so once again, as a landlord, I'm assuming that those landlords in North Carolina or in Kentucky are going to do a cost benefit analysis. What do I get if I win an eviction? I get the place. What do I get if I wait and help the tenant apply for this rent help? Well, maybe I get all the money back that I've already lost. So that's the cost benefit analysis that landlords are going to have to do. Now, some landlords are going to say, I'm so tired of this tenant. They've been yelling at me saying that you can't evict me. You can't evict me for, 15 months. I think that's the first time I've done that. Sing what tenants are saying to landlords. That's what landlords are telling us they're hearing from tenants. Maybe those landlords will say, you know what, I just want you gone. I don't care that I'm never going to see that money again, or I'm likely to never see that money again. I just want you gone. But I'm thinking that most landlords who do the cost benefit business analysis are going to realize they want money. Filing the eviction the day they can might not be the best move. Talking to the tenant about how they could file the eviction probably is a much better move, because then the tenant might finally get motivated to go apply.
And I was going to make two quick comments, one of which is that Eviction Lab, which is a research group that Matthew Desmond, I think, kind of started. They have an app that sort of tracks evictions in certain states and cities. I'll put the link in the chat there, but it shows that there has been cases filed during the pandemic, and in some areas much more than others, due to what Mike was just saying in terms of what protections were in place. And so the other thing on this is, and I'm repeating myself again, but I just actually saw a national news article from CNBC that says there's many states that have given out less than 5% of the federal rental assistance that they've got, which again is what, doing the math just a minute ago, Minnesota's gotten out, at least through the Rent Help MN program. Well, I don't know how much percentage of the total amount, but of the number of applications, they've gotten to 3 or 4%. So that's just a lingering issue that will have an impact on how people are able to stay or not. Okay, we got a question from Terry. Any idea when a landlord can non-renew a month-to-month lease?
And I don't have the articles in front of me. What is MinPost or the Minnesota Reformer reporting about non-renewals or terminations of the lease? When can those happen, according to the rumored deal? I think you're on mute there, Eric.
Thanks. I was trying to find the article.
I honestly couldn't tell. I thought maybe you were just reading by moving your lips. So I wasn't sure that you were muted, but that's okay.
Again, I'll put the Minnesota Reformer article in the chat, and you should read the bottom. Starting 15 days after the agreement, landlords will be allowed to bring evictions for material breach other than non-payment. 45 days, non-renew a tenant's lease for non-payment of rent if they're ineligible. for rental assistance. 75 days, evict for non-payment of rent if ineligible for rental assistance. So that's what's being reported by the media, but no final
Right.
deal that we're aware of.
There's no way we're going to say this is what's going to happen until we see it finalized, and that's a complicated, staggered system for sure. Yeah.
Okay. Eric, a question or a clarification from Eric. To clarify, if a tenant has applied and receives funds for their past due balance through June, what happens if they're still unable to pay for future months? Are they protected from eviction through June of 2022? Are they eligible for further assistance funds? This is a question on what's being reported in the media.
Yeah, hard to know whether they'll be protected through 622. As I understand it, there's the potential that future months' rent will be covered or could be covered eventually. I don't think that they're doing that to start. As I understand it, through rent help, from what we've heard from those folks, that they're going to pay back rent first, and then they'll look at prospective rent going forward once they get the back rent issues all settled for people. So I'm not sure about the time frame of that, but I think it's possible to get, if not more than one payment, at least payment that will go into the future as well.
Yeah, and Rent Help MN has sort of they've added some stuff to their website in the past week or two. One of which this is not new, but they're in there's two phases of Rent Help MN, and the first one is focused or prioritizing people with past due rent who can also apply for upcoming rent. But then there's going to be this phase 2 for upcoming rent. Don't know all the details on that, but and then they've also added to their website, I think in the learn more section, actually a diagram of how an application goes through review, what actually happens in the whole process. So I'll put that link in the chat. Okay. And then a question from Anonymous: does lease term maybe mean lease termination? From previous question. Oh, meaning when can
lease? Yeah.
Okay, so that's the question.
Maybe so. So I guess we did just answer that one, that, you can look at the Minnesota Reformer article and read what that says. Right now, though, a landlord cannot non-renew a lease. They can't terminate a lease at the end. That's different from an eviction. An eviction is a court case the landlord files for all kinds of different reasons, usually for non-payment of rent. A non-renewal or a notice to quit or a notice to vacate is generally given usually at least a full rental period in advance, depending on how the lease is set up, where the landlord will say something like, hey, today is June 16th, your lease ends the end of July. I'm not renewing the lease. Here's your notice. And right now that's not allowed under the governor's moratorium on not just evictions, but evictions plus non-renewals. It's a little bit understated when people say there's an eviction moratorium. It's more than that. It's an eviction and non-renewal moratorium that's in place currently.
Right. Maria asked, do you know if the landlord filed for the CERA program? So that's the COVID emergency rental assistance program through the Rent Help MN. So if the landlord filed for the CERA and the tenant leaves before CERA pays, or maybe this is through the Zero Balance Project, I think it's the same pot of funding. Anyway, if the landlord filed and then the tenant leaves before CERA pays, since the claim was filed prior to leaving, will the landlord be reimbursed?
I'm not sure about this one. Do you know the answer, Eric?
I'll see if I can find it. Again, I think that's a question for looking at Rent Help MN's website or calling 211 to get the details on that. In regards, okay, this is back to Keith, who had asked a question before regarding rent due in March of 2020. I'd filed for eviction days before the moratorium. It had been sitting in the county courthouse ever since.
I'm not sure what the status of that case would be, Keith. You can go online to a system called Minsus, and Eric might be able to link that up in the chat section, and you can look and see if that case is still active or not. It may have been simply dismissed at this point, not sure. On a case-by-case basis, that's probably the starting point that I'd recommend Anybody can use Minsis. It's the Minnesota Court Information System. You don't need to be a lawyer or have some sort of special password or pay a fee. It does ask you to prove that you are not a robot. And on almost every first attempt that people make, you will fail. It'll ask you to retype a series of letters and numbers. And I get it right once out of every 10 times on the first try. But it recognizes that I can't understand that. So it puts it up a second time, and it's a lot easier to read the second version. So don't just give up when you're looking to see where your case's status is. The best answer I can give you on this, Keith, because like I said, your question is something that I hadn't really thought about for maybe a year, is you could look at EO 2079, and Eric, if you could put that in the chat as well. It does discuss something about a writ having been obtained already. And I don't know if that's where you were in the eviction process. It sounds like you weren't. But number 5 of 20-79 talks about writs that were obtained prior to March 24, 2020.
Okay. All right. So this is maybe the last question again. Attorney did serve tenant with a notice to quit on February 3rd, saying they need to vacate by midnight on March 31. They never left.
So that's last calendar year, not this year. So we're talking 18 or 15 months ago.
Yep.
Right. Yep.
And so that was a notice to quit and vacate, but it wasn't a writ. Right.
So they never left. Does this still stand or have any teeth anymore? They were month to month at the time. That's a different question, actually, I think. So, all right. So a notice to vacate was given for the end of March. The landlord couldn't enforce it on April 1 because they weren't able to file an eviction. And at that point, they would have filed an eviction for what's called holding over. Could they still rely on that notice to vacate once they're able to file an eviction for holding over once those doors open up at the courthouse? I would bet no. I wouldn't try it if I were a landlord attorney. I would say once we're able to give a new notice, you should give a new notice. Another defense to that might be if you've accepted rent or even asked for rent for April 1st of 2020 through now, then arguably you've waived the right to enforce that notice to vacate. A landlord would argue, this actually gets into some pretty theoretical, interesting questions that people that work in my world might have wondered about sort of tangentially before the pandemic, because it wouldn't matter because it would never happen, but it happened. So what if you're forced to not be able to file an eviction for holding over and you decide to accept rent? Are you then waiving that right to evict by accepting rent? And I would guess maybe. I would absolutely recommend, if I were a landlord attorney in that situation, that once you're able, you give a new notice to vacate and enforce it at that point. I would not rely on that March 31, 2020 notice to vacate to hold up anymore.
Yeah, and then a related question from a social worker: what exactly is a notice to vacate? What legal force or purpose does it serve? Feels like tenants, landlords, service providers all think it means different things. Thanks for.
Yeah, no, it's a great question. And I imagine that over the 53 speeches that we've done, we've been somewhat guilty of this too, where interchangeably the words eviction, notice to vacate, notice to quit will be thrown around, non-renewal. And they're not the same. And the easiest way to separate them out again is, an eviction, formerly known as an unlawful detainer. The key differentiator there is that a court case was filed. The landlord paid $300 to start the case. And there was a court date set, and maybe there was a hearing, maybe there wasn't, but that's the key separator. An eviction means that a court case was filed. There's actually a definition of what an eviction is. A notice to vacate, a notice of non-renewal, a notice to quit. Usually we use a notice to vacate or a notice to quit when we're talking about what's called a periodic tenancy, typically a month-to-month lease. So every month the tenant pays their rent on the first of the month. That's the start of the rental period. The rental period ends on the last day of the month at 11:59 at night. That's the full rental period. And so if a landlord wants to give a notice to vacate, or if a tenant wants to give a notice to vacate that's properly timed, it would be during one rental period. So again, you could give notice today, June 16th. to leave, if I'm the tenant, to leave on July 31st, if they are a standard month-to-month rents due on the first tenant. And that would be a notice to vacate. It's called the same thing if landlords give it. Sometimes it's called a notice to quit. A non-renewal is traditionally used when we're talking about what's called a term lease. So a term lease is different than a periodic lease. Again, the periodic lease was the month-to-month lease that we just talked about. A term lease is more likely to be something like a 1-year lease or a 2-year lease or a 3-year lease or even a 5-year lease that I mentioned when I was talking about the foreclosure epidemic of 10 years ago. A non-renewal is traditionally given a couple months, most of the time in Minnesota, by the landlord to the tenant saying, hey, your lease is up August 31st. And the lease requires 2 months notice, and I'm non-renewing your lease for August 31. On August 31, I need you to move out. I'm going to sell the property. I'm going to move in myself or whatever. The tenant also would decide to not renew their lease or give a notice of non-renewal for that same amount of time. They give the 2 months notice. So hopefully that makes it a little clear. Again, I know that I use those interchangeably, kind of sloppily. Sometimes it's a little bit slangy, but that was more of a dictionary definition of the difference between a non-renewal, notice to vacate, notice to quit, and an eviction itself. But I absolutely don't mind asking for that kind of clarification. Thanks for trying to make that straight for us.
Yeah, all right. John, a housing attorney, are you aware of any enforcement actions taken by the Attorney General's office in cases where a landlord or family member failed to move into the unit within 7 days after terminating the lease under the family member move-in exception in EO 2079 paragraph 4?
There was a case, I want to say in Apple Valley, that was brought by the Attorney General's office, a violation of the family member move-in exception. I'm not sure if those were the exact facts there, John. John, by the way, John Buda is an attorney that has appeared on this program. Do we call it a program? On these webinars before, and we are very grateful to have him. May have him again sometime. You never know. Anyhow, I'm pretty sure there was an Apple Valley case. I can't remember exactly what the sense of it was, but sort of the biggest problem with trying to figure out the answer to John's question is we don't know the vast majority of Attorney General enforcement actions. I mean, if he's talking about simply court cases that are filed, those are public record. But a lot of the time what the AG's office has done is just called landlords and said, hey, this is what we heard. Is that right? Because if so, you can't do that. I think that is far and away the primary enforcement mechanism that the Attorney General's office has been using. Instead of filing endless court cases against landlords, they say, stop it or else we'll file one of those court cases. So I think the court cases have ended up, and I'm not sure if this is by design or just practically speaking, the court cases have ended up being example cases that the Attorney General has used to make sure that other landlords are aware, hey, you better do what the AG's office says under this rule, or else the AG will take this seriously.
Right. I have been looking it up. I think the question that Maria asked is that it's possible that landlords may have to return funds if the tenant no longer resides in the unit. At least it says that at renthelpmn.org, because one of the federal rules is the tenant has to be residing in the unit.
The sequence would be the tenant and the landlord apply, and the application is being determined, tenant leaves, then the check comes, and then the landlord cashes the check, right? That's what you're describing there?
That I think was her question. And that's what it says, but we're not experts again in the Rent Help MN program. There is a section of their website that is meant for landlords, and it looks like they've been posting updates there. So it's worth taking a look at the Rent Help MN website, which I put the link just a few moments ago in the chat. We'll take a pause here while I put the links to our registration for the future sessions. Again, we gave the news that has been reported, much of which came out on Monday and Tuesday of this week regarding negotiations at the legislature about the off-ramp. The details are not final yet. It's not a law that has been passed or even a law that's posted somewhere to be seen by the public, at least at this moment. So we may have news in a week from today. And so here's the next two upcoming sessions on Wednesday, the 23rd, and then the 30th, with the thought that we'll probably have news about a variety of issues on both of these days regarding an off-ramp or the CDC suspension.
And again, I'm doubtful that we'll know much about the CDC at this time next week, just from past deadlines that had been looming. I don't think we ever saw an extension announced that early, a full week before. So there is a reason why we're guaranteeing that we're going to do on June 30th, and June 23rd makes a lot of sense right now because of the fact that there's so much movement right now, if it feels like, in the direction of an off-ramp. But the CDC one, I don't think we'll know the answer on June 23rd.
All right. Well, we haven't gotten done early in a while, but we're not seeing any more questions.
Yeah, that's fine.
Maybe there'll be a lot more questions next
Oh,
week.
there were plenty of questions. What did we finish? 4 minutes early?
Yeah.
Okay.
Okay, well, with that, I guess not seeing any more questions in the Q&A system. Thank you for joining us, and feel free to register, sign up for our session in the next coming weeks, next Wednesday and the following Wednesday. And thanks for joining us today. Goodbye.